On this week's episode of the podcast, lions and tigers and bears, oh my.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law, and I have an episode for you today that's based on a couple of listener interactions that I've had over the last couple of weeks, plus an update from 2 weeks ago when I did an episode on title insurance, and I promised you all some more content on the differences between the various deeds, and that actually inspired the title to today's episode. So one of the things that I remember growing up is watching The Wizard of Oz with my parents, and there's that scene when they're going down the yellow brick road. Dorothy and I think the Scarecrow are going down the yellow brick road. I think it's Dorothy, the Scarecrow, and the Tin Man are all going down the yellow brick road, and they talk about, we might bump into lions, and we might bump into tigers, and we might bump into bears, and Dorothy's line is lions and tigers and bears, oh my. And so the reason I thought of that is because in talking about deeds, we've got three different types of deeds here in Florida. Warranty deeds, special warranty deeds, and quitclaim deeds. Oh my. So what I thought I'd do is do a little bit on the differences in those three types of deeds, and then get into a couple of listener interactions that I was extremely happy to have, but I'm sure if they have these questions, then some of you may have these types of questions too, and it all relates to deeds and mortgages and priority in Florida and homestead and all that stuff. Now, before I really jump into the content, I did want to mention our sponsor, Sam Cohen of Attorneys First Insurance. And as some of you longtime listeners will know, Sam writes malpractice insurance, E&O insurance, errors and omissions insurance, professional liability insurance. It's all the same thing. Basically, malpractice insurance for attorneys and title companies all over the state of Florida. He also has a particular focus on Texas right now, but really anywhere in the country he can write this type of insurance. So if you know an attorney or title company and their E&O renewal, their malpractice renewal is coming up, a great way to support the show would be to support Sam, and a great way to support Sam would be to refer that attorney or title company over to Sam. They can reach him at sam@attorneysfirst.com, or the website is attorneysfirst.com, just like it sounds. But let me launch into the content today as well. So warranty deeds, special warranty deeds, and quitclaim deeds. Oh my. So what's the difference between those three types of deeds? Well, a warranty deed is exactly what it sounds like. The grantor or the seller is giving a warranty to the grantee or the buyer that the title to the property is good. Now, I talked a couple weeks ago, and I've talked before about title insurance. And so if the title is not good, and I've actually got a case right now where somebody bought the property, and then soon after buying the property, they got a claim, they got sued, somebody else claiming they had a better title or better right to the property. And so we tendered it to the title insurance company. And so the title insurance company is handling it, is defending the lawsuit. But the purpose of the warranty deed is that the buyer could potentially sue the seller for that warranty. The buyer could contact the seller and say, hey, you gave me a warranty that the title was good. I'm being attacked over the title right now, and so, seller, you need to defend me from those claims. Even though I have title insurance, seller, you gave me a warranty that the title to the property was good, and you need to defend that title. That's a warranty deed. The other type of deed that we oftentimes talk about is called a special warranty deed. So the difference between the two, a special warranty deed is also a warranty deed, but it's a warranty deed with some conditions, with some exceptions. So just like a title insurance policy would make exceptions for things that are known or found or discovered in the title search, the special warranty deed also makes exceptions. So the special warranty deed is seller saying to buyer, I will give you a warranty and I will defend the title to this property except for these known things. Maybe there's an easement, or maybe there's rules and restrictions, the rules and restrictions on the plat of the community, or those types of things. And so basically the seller's saying, hey buyer, I'm going to give you a warranty that the title is good. subject to these things that we know about. And these things that we know about are also going to be exceptions in the title insurance policy, so you wouldn't get title insurance coverage for those things anyway. Special warranty deeds are used a lot when a bank conveys property. So if a bank takes title in foreclosure and then conveys the property to a buyer after taking title in the foreclosure, a lot of times the banks will use a special warranty deed to convey the property to make sure that the bank is disclaiming any liability for things that they know about within the title search. A lot of times special warranty deeds are also used in commercial situations, whereas a warranty deed is most often used in just a residential buyer-seller transaction because, again, you've got the title search, you've got that background, you've got the title insurance policy as well in a warranty deed and a special warranty deed situation. The last type of deed is called a quit claim deed. Now, I want to be really clear there. Q-U-I-T, quit, as in, hey, boss, I quit. Quit claim deed. A lot of people call it a quick claim deed, Q-U-I-C-K. And I guess maybe the reason a lot of people call it that is because it's very quick to prepare. Now, again, all three of these types of deeds can be prepared relatively quickly. All you need is the buyer and seller's names, their addresses, the property address, the legal description, and you can pretty much prepare a deed fairly quickly. But it is not a quick claim deed. It is a quit claim deed, Q-U-I-T, just a little pet peeve of mine. Now, a quit claim deed, where a warranty deed and a special warranty deed are a warranty from the seller to the buyer, a quit claim deed says, I don't know what I got, but whatever I got, you got. You know, hey buyer, I don't know what my title is to this property, but whatever it is, it's now yours. So for example, I could give you a quit claim deed to my house. Now, since I own my house, you would then own my house. I could also give you a quit claim deed to the land that USF, University of South Florida, sits on. I could give you a quit claim deed to that land. Now, because I don't own that land, you don't own that land either, but it doesn't prevent me from giving you a quit claim deed for it. It's, hey, whatever I got, you got. So if I don't got nothing, you don't got nothing. So typically, quitclaim deeds are used in family situations. So mom and dad want to convey the property to their kids, or brother wants to convey to sister, or brother and sister inherit the property and one wants to convey to the other. Typically, quitclaim deeds are not used in situations where there's going to be a title search or a title insurance policy, although I think there can be a search. I don't know that a quitclaim deed can form the basis for a policy, a title insurance policy, but you could certainly do a search and then do the quitclaim deed. There wouldn't be any of that title insurance, but you would have some due diligence that the title's clear. But again, typically, quitclaim deeds are used between family members. Maybe husband and wife are getting divorced, and the divorce court says, hey, husband, you have to give your share of the house to the wife, and so the husband would do that by way of a quitclaim deed. So again, it's not a quick claim deed, it's a quit claim deed, Q-U-I-T, quit claim deed. Those are the three different types of deeds: warranty deed, special warranty deed, and a quitclaim deed. Oh my. So I wanted to go through that, number one, because I know that I had promised you all some additional content around the three different types of deeds in a previous episode. But again, the concept of the deed and then the note and the mortgage comes into play for a couple of these listener questions or listener conversations that I recently had. So the first one was with a listener named Cheryl. Now, Cheryl, thank you for calling in. If you're listening, thank you for listening. I won't give a last name for privacy purposes, and I really hope you don't mind. I'm going to give a very basic example of what we talked about so that I can explain to all the listeners, and all the listeners can get the benefit of our conversation. So Cheryl called in. She is separated from her husband, and they are in the process of a divorce. They've been separated for a while, and they're in the process of a divorce. Now, after being separated, but before the divorce was filed, her soon-to-be ex-husband bought a house that he's designated as his homestead property, but in the deed and then in the mortgage, he represented himself as a single man. Now, one of my questions was, maybe it's an innocent mistake, and he thinks, since I'm separated, I am single. And unfortunately, in Florida, that is false. If you're either married or you're divorced. You're either married or you're single in the state of Florida. There is no such thing in the state of Florida as a legal separation. And so, I always like to give people the benefit of the doubt and say maybe your soon-to-be ex-husband didn't realize that and figured I'm separated, so I'm as good as single, and let me represent myself as single on the deed and then on the mortgage. The problem is, when he filled out the homestead application for the property, he did represent himself as married. So at least the soon-to-be ex-husband here knows that I am not, in fact, single. I am actually married. And so we talked about it for a little bit, and I think we ultimately decided I don't think there's anything really I can do about this situation. There's nothing that I'm not a divorce attorney. I'm not a family law attorney. I would be lost in family law court. I would probably get my butt kicked in family law court. So it's really not a good idea for me to be representing people, and I don't represent people in family law court. I refer those out. I've got a bunch of great friends that do divorce law, and so if that's a scenario that you find yourself in, certainly give me a buzz. I'm happy to talk to you, and I'm happy to refer you. This listener actually has a divorce attorney, so she's in good hands. From what I know, I actually don't know her divorce attorney, but I assume if she's comfortable with that attorney, then she's in good hands with that attorney. And so I can refer you to a divorce attorney if you need that referral. But in this case, there's really nothing for me to do from a real estate perspective. I don't know that I could find a lawsuit and sue the soon-to-be ex-husband for the way that he represented himself in the deed and in the mortgage and then in the application for homestead. Now, why is that sort of important? Well, the mortgage, if the bank knew that he was married at the time he took out the mortgage, the bank would have required that his wife, even though they were separated, sign the mortgage. And that's because of the homestead laws in the state of Florida. And I've talked about homestead laws in the state of Florida before. And so if the bank had known that fact, they would have required that the separated wife sign on the mortgage, because otherwise the bank does not have a full interest in the property. And so in essence, we think that the ex-husband or soon-to-be ex-husband actually may have defrauded the bank in the way that he got this loan, especially if we have the homestead application that proves that he knew that he was in fact married at the time. And so that is, I think, where the leverage lies here. In other words, our listener can use this information when she's in the divorce mediation or in the divorce trial and possibly show that the husband used marital assets to buy this house and then misrepresented himself to the bank as being single to get a loan without the wife signing, presumably also to hide this house from the wife, although I don't really know in this scenario how you hide things from the public records. There are ways to do it with land trusts and LLCs and that kind of stuff, but the husband wasn't that smart in this case, and so all of this stuff is public record, so it's not hidden from the wife. But, again, the husband maybe used some underhanded tactics to get this house, get the loan, live in this house, live in this homestead, get all the benefits of the homestead, using assets that presumably should have belonged to both husband and wife jointly. And so maybe that's a leverage point, maybe that's a pain point that the wife can use in mediation or in trial to get a more favorable outcome for herself. And so, Cheryl, thanks again for calling. Thanks again for talking. Thanks again for being a listener. And I really wish you the best of luck in everything. Please keep me posted on how things go in terms of how you're doing, and I appreciate the comments, and I appreciate the call, and I hope you don't mind me sharing the basic fact pattern so that other listeners can benefit from our conversation as well. The last listener that I want to talk about is a listener named Jill. And again, this issue of deeds and priority and mortgages comes up again, which is the central theme running through today's episode. And so Jill's parents were both on title to a house. So mom and dad, as husband and wife, were on title to the house. Mom and dad took out a mortgage to buy this house. Mom and dad lived in the house. Well, unfortunately, some number of years ago, dad died. Well, when dad dies, because mom and dad are husband and wife and are on title as husband and wife, mom, the wife, got 100% of the ownership interest in the house. It's called tenancy by the entireties. And again, tenancy by the entireties is something that I've talked about, again, time and time again on previous episodes of the show, but it basically means husband and wife are in title to the property as husband and wife. And it has to say as husband and wife on the deed. But if they're in title as husband and wife, if one spouse dies, the other spouse automatically, without probate, gets that 50% interest in the property and owns the property 100%. It's also called joint tenants with rights of survivorship. So, in other words, you and I could be on title to a house as joint tenants with rights of survivorship. And if I pass first, you would automatically inherit my 50% interest in the house. You would own the house 100% without any probate, without nothing. All you would have to do is record either my death certificate or a short form of my death certificate, and that would give you full and complete title to the house without any further action by you. So mom and dad are in title, dad passes away, mom owns the property 100%. Well, mom then refinances the property. I don't know why, maybe to get the husband's name off the mortgage, maybe because she needed some extra money, maybe for whatever reason, mom refinanced the house. So now mom is in title alone, the mortgage is in mom's name alone, and then unfortunately, I think in 2018, I want to say, mom passes away. Now when mom passes away, now there's a probate necessary because mom is in title by herself. Now, Jill and her brother are mom's sole heirs, and they're both the children, and they're both adult. So we got no issues there. If they were minors, we might have some other issues that I can get into here in a future episode, but they're both adults, so they are the heirs. Now, again, I don't do probate law, just like I don't do family law, but I know enough about it and how it relates to title, and I've got a couple of probate attorneys and elder law and estate planning attorneys that I can refer to. A bunch of them have been on the show. Lee Carr's been on the show. Michelangelo Mortallero has been on the show. A couple of my other probate and estate planning friends have been on the show, but again, I can refer you to a bunch of them. And so, but in this case, Jill and her brother decide not to probate and not to take over the property because at that time, 2017-18, the house was upside down. And so in order for Jill and her brother to really take over the house, they would have had to either pay off mom's mortgage or they would have had to sell the house. And with there being no equity in the house, there was no benefit to them to selling the house. Now, interestingly, I'll take a little side note here, a little detour here. A lot of people are opposed to reverse mortgages. And the biggest complaint I hear about reverse mortgages is, well, the bank's going to take back the house when mom dies or dad dies if we don't pay off the mortgage. Well, that's exactly what happened in this situation, and it was a forward mortgage. So don't be afraid. I'm not saying a reverse mortgage is the perfect tool in every scenario, but what I'm saying is this criticism of a reverse mortgage that, well, the heirs are going to have to pay off the mortgage. Well, that exists in a regular mortgage situation as well, as it existed in this case. Mom passes away. The house had no equity. Brother and sister decided to let the house go. Well, what happened was when mom died, the payments stopped to the bank. Brother and sister decide we don't want to keep this property, so we're just going to let it go. So the bank started a foreclosure lawsuit. Now, here's the interesting issue in Florida. Florida law says that an estate cannot own a home. Now, a lot of times it'll be titled in the name of the estate when the homeowner passes. But really, the estate doesn't own the property. The property goes somewhere. Now, the probate is used to determine where the property goes. And maybe once the probate is over, you have a formal ruling from the court that says the property goes to brother and sister, or the property goes here or there, or whatever. And that's what the probate is used for. But technically, the house goes somewhere. It can't just sit in an estate. I think that's a way to think of it, but from a technical legal perspective, it's not entirely correct. So in this case, the bank had to foreclose on brother and sister as well, because the bank had to have the court determine that its interest in the property through the mortgage was superior to brother and sister's interest in the property through being an heir of mom who's deceased. And so brother and sister become defendants, and they get sued in the foreclosure lawsuit. Foreclosure lawsuit ends in 2019. The bank successfully forecloses. The bank takes title to the house. The bank resells the house at some point. Now, the reason that Jill called me, the reason that the daughter called me, is because she's trying to buy her own house. And in the process of buying and she doesn't even live in Florida. She lives outside of the state of Florida. And she's trying to buy a new house. Now, in her lender doing its due diligence, they see that this bank has a judgment, mom's bank has a judgment against her, which technically is correct. They have a foreclosure judgment against her. They have a judgment against her that, in essence, says the bank's interest, mom's bank's interest in mom's house is superior to daughter's interest in mom's house and brother's interest in mom's house. And so the daughter's new lender won't give her a loan to buy a house because she's got this foreclosure judgment against her. And so what I had to do is write an opinion letter to the bank to say, okay, lender that's trying to give daughter a loan to buy a house, here's why you're wrong in your analysis. And I came up with 3 different things that apply. Some of them apply in every case. Some of them apply specifically in this case. So number 1 applies in every case. There's no privity of contract. Now, privity of contract is a concept we learn in law school, and privity just means some connection. You and I sign a contract, there's privity of contract between us. You and I sign a contract, there's no privity of contract between you and my wife because my wife didn't sign that contract. But you and I sign one, there's privity, there's that connection, there's that nexus, there's that thing that we've both entered into this contract. Well, remember, I've talked before on the show, the note is what says you owe the bank the money. The mortgage is the security interest against the house. You don't repay the note, the bank can take the house by the mortgage. Well, here the daughter didn't sign the note and didn't sign the mortgage. So the daughter owes no money to the bank because the daughter did not sign the note. And then the mortgage, the security interest, is superior to the daughter's interest by being an heir. And that was the foreclosure. That was the purpose of the foreclosure. But because the daughter didn't sign the note, the bank has no authority to chase the daughter for money. So even though there's a judgment against the daughter, the bank has no ability to pursue the daughter for money because the daughter didn't sign the note. There's no privity of contract there. Number 2, the daughter was only listed in the foreclosure as an heir, again, so that the bank could have the judge determine that the bank's interest in the property was superior to the daughter's interest in the property. And again, this is common in the state of Florida in scenarios like this where mom dies, dad dies, and there's heirs involved. Typically, all the heirs get named. Typically, unknown heirs get named, and there's an attorney ad litem or guardian ad litem who's appointed to try to find and protect the interests of those unknown heirs. I've been a guardian ad litem, an attorney ad litem in cases filed by other attorney friends of mine. I've had them appointed as attorney ad litem in cases that I filed, foreclosure cases that I filed. So again, it's a fairly common practice here in the state of Florida, and I explained that to the bank as well. The last point is something that applied specifically in this case. So the foreclosure was in July of 2019. The foreclosure sale and the bank's certificate of title were both in July of 2019. Well, under Florida law, there is a 1-year statute of limitations for the bank to collect deficiency following a foreclosure. So the bank's statute of limitations to pursue anyone for deficiency expired in July of 2020. Now, as I talk to Jill and as I record this episode, we're deep into 2021. By the time this episode is released, we're in early December 2021. And so there were a year and a half beyond the expiration of the statute of limitations. And so I explained to the daughter's lender that's trying to give her the loan to buy the home, hey, we're beyond the statute of limitations anyway. So even if I'm totally wrong and the bank says, we don't care about privity of contract, we're going after the daughter, and the bank says, we don't care that we included her only as an heir, we've got a judgment against her, so we're going after her. Well, bank, you waited too long. You had to pursue the daughter before July of 2020. We're now in November, December of 2021, and you haven't done it yet. So you're beyond the statute of limitations. You lose for that reason as well. Now, the bank's not going to pursue the daughter based on points 1 and 2, based on privity, based on being an heir. They're not going to pursue her anyway. But again, even if they tried, they'd be knocked out by the statute of limitations. So that's 3 different reasons in this particular case that the bank cannot pursue Jill. Mom's bank cannot pursue Jill for any deficiency created by the foreclosure on mom's house. And so I wrote a letter for Jill to give to her lender that says, hey, I don't owe this bank any money. Therefore, there's no risk here of any foreclosure. I'm not a foreclosure risk. I didn't not make payments on my mom's loan. I didn't have to make payments on my mom's loan. And so therefore, bank, you should give me a loan so that I can buy a house. Now, I don't know if it's worked. I assume it will, but I have no idea. I've got to sign the letter today, send it over to the client, and have her present it to her lender. I assume it'll work. But again, if it does or if it doesn't, maybe I'll update everyone on a future episode. So again, I think that'll do it for today's episode. All of this sort of relates to the different types of deeds that we have, the priority of mortgages, the contractual obligations due under a loan, under a note, homestead laws in Florida. All that stuff sort of wraps up to make today's episode. Lions and tigers and bears. Oh my. So if you have questions about deeds, if you have questions about mortgage priority, notes, mortgages, any of that type of stuff, please reach out. I love talking to listeners. I very much appreciate you all listening. I will talk to you as a listener. If you have questions, let me know. If you're outside the state of Florida, I may not be able to give you the best answer, but I'll at least talk to you and see if I can get you where you need to go with an attorney in another state. And so, again, I think that'll wrap up this week's episode of the Crushing Debt Podcast. I hope that at the end of the month you have more money, rather than at the end of the money you have more month. And I look forward to talking to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.